Well, good evening. My name is Blake Bingham. I'm the Adjudication Program Manager for the State of Utah Division of Water Rights. This is the public meeting for the Draper Subdivision General Adjudication or Water Rights Adjudication. There's not very many people in the audience here tonight, but we do notice that there are some online viewers, so I'm going to go through this presentation. As usual, we may have some people kind of filter in. For those of you viewing at home, you might see some people kind of wander past the cameras, but we'll go ahead and proceed. We understand that if there are questions, feel free to ask them throughout the course of the presentation. I was just explaining, I'm actually filming this online, so I'm going through the presentation. Welcome, have a seat, sit wherever you feel comfortable. We'll make this informal, okay? If you guys do have any questions, go ahead and ask them throughout the presentation. I'll probably end up repeating them just for the benefit of our online viewers as well. Like I said, I'm Blake Bingham. I'm the Assistant State Engineer for the Division of Water Rights. This is the public meeting for the Draper Subdivision of the Water Rights Adjudication, often referred to as Area 57, Book 26. Here's our agenda. We'll kind of go over the overview of the adjudication process, talk about proposed determination, some of the significant issues and anticipated timeline, and then questions throughout. For those of you who are viewing online, if you have a question, if you want to use that email address at the bottom of the screen there, waterrights_adjudication@utah.gov. If you email me those questions at the conclusion of this presentation, I'll check that email and I will read them out loud and answer them for the benefit of the group. If I don't get your questions answered, this email will be shown again at the conclusion of the presentations. I'll give you some time once we're done here to fire those off. If I don't get to those questions, I'll still respond with an email to those who email those questions in. This is also a good email address to use for any general questions. Okay, so when we do these public meetings, we typically start off talking about what a water right is, just because there's not the level of familiarization with what water rights and adjudication is varies across the group. So we kind of start at Water Rights 101. Water right is the right to remove or divert water from a source, a natural source. And it typically has a couple different characteristics. First of all, it has a defined nature of use. That's going to be what it's being used for, whether that's for irrigation, whether that's for stock watering, for domestic purposes. It'll have a priority date, and that in essence is where it falls in the line of getting its water. So older priority dates get their water first, junior priority dates or more current priority dates get their water after the more senior ones. Defined quantity of water, we measure that in acre feet per year or cubic feet per second. So one's a flow rate, the CFS, cubic feet per second. The other is an annual diversion in acre feet per year. And you can imagine what an acre foot is if you just imagine a property that's 1 acre in size and water that's 1 foot deep. That's the volume of acre foot. It is what it sounds like. Feel free to have a seat wherever you'd like. We have a specified point of diversion. That's really where the water comes out of the source. So if you have a stream, it's going to be a head gate. If it's a spring, it's going to be a spring box. If it's a well, it's the actual well. So when we talk about point of diversion, that's the generic term we have for those types of structures. And then a specified place of beneficial use, that's just where it's used, and we measure that using the public land survey system. It's just kind of a grid that's projected over the state of Utah. We can identify where a point is anywhere in the state using that grid. Usually when we send out these notices and these summons, and I failed to make this clear at the onset of this, but you know, when we send these notices out and these summons, the summons packet that you received that notified you of the meeting here tonight, there may be some confusion as to what that is, and I understand it's probably some concern whenever you receive a summons from the state of Utah in the mail. You're not in any way obligated to be at this public meeting. For those of you here, you can leave at any time if your curiosity has been satisfied. That's just a statutory requirement. We have to send summons because it is a legal proceeding. So I apologize for if that was intimidating or scary. To be honest, we're here to try to help you navigate this process. Although it is a legal proceeding, we try to be as informal as we can and help people understand what the steps are to navigate it. But when we send these notices out, we get a flood of phone calls, and the most common question we get is, how do I know if I have a water right? You know, a lot of houses in the Salt Lake Valley you had these wells that were drilled, and then eventually Salt Lake City or maybe Draper Water Company or some other water company hooked them up to culinary sources, and they stopped using their well for their own domestic purposes and maybe use it for the lawn. And then people sell their houses and move in, and they don't understand. They see a well, but they don't understand there's a water right associated with it. And some people just think, well, if I own land, there must be water rights associated with that land. The quick and dirty answer is, if you have, there's certain things that may evidence the existence of a water right on your property. The biggest indicator in this area is going to be the existence of a well. So if a well on your property that you've been using, it may suggest that there's an existing water right of record. Also, if there are irrigation ditches or even spring boxes, those are also indicators that there may be water rights associated with your property. What a water right is not. So this is where we kind of get in the weeds a little bit, and I think a lot of people in this particular subdivision probably fall into this category. A water right isn't a share in an irrigation company. The irrigation company has water rights, but they own them, and then they administer water or provide service to their shareholders. So if you're a shareholder in an irrigation company, you have shares in that company, but the irrigation company owns the water rights, and they're the ones who would be responsible for participating in this process. Also, it's not a connection to a public water supplier, such as a municipality or any other one that provides you your culinary water. You know, if you have a water meter and it comes in off the street. Again, they have water rights, and they are participating. They're actively participating in this process, but that doesn't require you as a customer of them to participate directly, okay? Certainly, you can make sure that they're on the ball and they're doing what they can. I can assure you, for the most part, municipalities are all over this. They understand the process. We've had a lot of conversations with them. Some of these irrigation companies, that's kind of hit and miss. Depends on the size of the irrigation company and how sophisticated they are. The bigger ones tend to understand this process, have attorneys who understand this process. The smaller ones that are just kind of ran by a group of residents may struggle to understand this. So if you are a shareholder in that type of company, I would recommend being involved and making sure whoever is running the company is involved and contacts us so we can help them navigate this process. All right, so I'm going to do a quick history tour. Apologize, it's going to be fast, but really to understand the concept of why we do water rights adjudication, you got to understand where it came from and the evolution of water rights in the state of Utah and really the western United States, okay? So we'll start off with the beginning. We all know the story. Brigham Young landed with an advance party of Mormon pioneers in July of 1847. Right away started diverting the waters of City Creek to kind of soften up the soil to plant a late season crop. Then they built their shopping mall on top of it. Later the following year, Brigham Young kind of made this statement that said, there shall be no private ownership of the streams that come out of the canyons. They belong to the people, all the people. And that's really the fundamental principle of Utah water right laws, that the waters aren't owned by the state, they're owned by the people. They're a resource that is owned by all of us, okay? It's a natural resource. The state simply helps to administer the orderly diversion and appropriation of those rights so that it's not, there's not a lot of lawsuits, and we'll get into a little bit of that. Well, between 1847 and 1850, what we now know as Utah went from being part of Old Mexico to this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. However, regardless of what type of, I guess, country it belonged to, the government was really still church-centric. And when I say church, I'm talking about the Church of Jesus Christ of Latter-day Saints, otherwise known as the Mormon Church. Just because they were there, they filled that power vacuum. But why is that important? Well, because that was the case, diversions of water from the streams were generally on a communal basis, and they're only done to satisfy the immediate needs of the settlers. And that as a result, the doctrine of priority kind of evolved with that, in that the settlers that would settle these different places first would start diverting the waters, start irrigating their crops, and then they would have the first call on the water. But subsequent settlers would come in, and they wanted to share in the water, but they said, all right, after we've taken all of our share, then you can have some. So this concept of primary rights versus secondary rights evolved, and kind of actually Utah, or what we now know as Utah, is kind of the center for that, and it was exported to other states in the West. Also, because it was church-centric, the government was, all of the conflicts were settled through ecclesiastical channels. You had bishops' courts for kind of local conflicts where the bishop would preside and say, no, you're right, you're wrong, he gets the water at this time. And if they didn't like that, they could appeal to the local stake high council, and they would say, oh, the bishop erred in his judgment. This is really how this water is supposed to be diverted. So we move on into the territorial era. Of course, when Utah became a territory, the first territorial legislative assembly attempted to kind of rein in the power from the LDS Church, and rather than having the church issue and decree water rights, they said, well, what we're going to do is have the county courts do it, all right? We're going to give the power to them to do that. However, Salt Lake County was really the only county to really do that, and back in those days, the judges of the county courts were elected. So you can imagine who was being elected to those offices. Well, it was going to be the same bishops and the same stake presidents. So in fact, there was really no difference as a result of that. In 1877, the Desert Land Act was passed by Congress, to promote homesteading and colonization of the West. The act also had some other consequences in that it severed title of the water from the land. Back east, if you lived adjacent to a river, you had an automatic right to divert from that river. It's called riparian doctrine. Well, this act kind of said, well, the West is too arid to be able to support that. We want to homestead it, and not everyone lives next to a stream. So what we're going to say is you homestead this parcel, and you've got to irrigate it. Well, you've got to figure a way to get the irrigation from City Creek or whatever creek down to your 40 acres. And so the consequence of that is that you no longer had an automatic right to water if you owned the land. You had to appropriate it, okay? And it also delegated the authority to appropriate those waters to the local government, whether that be territory or later state, which seems that makes sense to us in these days. But if you think of it, back then it was still the government land office was still issuing patents to land. You didn't acquire land by going through the state. You acquired land by going through the federal government. Well, this was different now. Now you acquired water rights by going through the territory or the state as opposed to going through the federal government. So that's why the Division of Water Rights, a state agency, is responsible for administering water rights as opposed to some federal agency. There was really a failure to be able to administer any water. They tried to appoint these county selectmen who would then adjudicate these rights, because there's some controversy. People would say, no, I have the right, and there was just a little bit of controversy over who could take as much water. And so what they decided to say, we're going to appoint these county selectmen, and they're going to adjudicate these issues. However, it was only really applied in Salt Lake County, and it was kind of ruled unconstitutional because it was an executive office official presiding over property rights issues, and the court said, no, that's our realm. So it didn't really go anywhere. As a result, there's a lot of confusion over existing water rights in spite of the best efforts of the territorial legislature or even the LDS Church. And the church continued to administer and decree water rights. An example I cite during these presentations is the 1879 High Council decision that divided the waters of the Spanish Fork River. And to this day, that's still how those waters are divided for the main part. There's been some subsequent decrees, but the church issued that decree, said these companies get this much, these companies get this much, and to this day, that's still how those waters are divided. So let's go into the statehood context and look at what happens when Utah became a state. Well, we know in 1896, Utah finally gained statehood. There was some real concern over the water users throughout the state of Utah, through the residents, that the state was going to confiscate all the water rights, all the property rights, and say, all right, no one has any water rights. We're going to gather them all in, and then we're going to hand them out. And there was a controversy because there were some people advocating for that because they said, how will we know who has water rights and who doesn't unless we just say there are no water rights, the state has them all, and everyone has to apply for them anew. And there was obviously the group of people who said, no, I don't want to lose my water, I want to continue to use it. And so what they decided to do is, hey, what we'll do, we will just not address any water law in the new state law. All we will do is provide one provision in the Utah State Constitution, Article 17, that says, all existing rights to the use of any of the waters in this state for any useful or beneficial purposes are hereby recognized and confirmed. So what they were saying is, if you've been using water and if you have a water right, you continue to own that, you continue to have that water right. Just because Utah became a state doesn't mean that that those rights are no longer valid. So in essence, it grandfathered everyone in at statehood, and that's important because that's going to tie into why we still are trying to find some of these rights to this day. Well, in 1897, the Office of the State Engineer was created. That's the kind of the historical name for the Division of Water Rights. So my boss is Kent Jones. He's the state engineer, or otherwise known as the executive director of the Division of Water Rights. But his responsibilities were simply for mapping out rivers and conducting hydrographic surveys. Appropriations were still kind of done in the old-fashioned way, where you'd go and pound your stake in by the stream and then go post it and then go file it at the post office or the county clerk. You can see Willard Young was the first state engineer. I'm sure you can figure out whose son he was, right? In 1902, the Reclamation Service was created, and what we now know is the Bureau of Reclamation. And their mission in life was to reclaim the arid West. And so they do this by going and building these huge projects. And when I say projects, I'm talking about big reservoirs, all right? And everyone in the West wanted these reservoirs in their state, because what that meant is they could then capitalize on some of this winter water and use it to irrigate during the arid months to satisfy those needs. Well, the Bureau of Reclamation said, hey, unless you have a water law that helps figure out these existing grandfathered rights and a way to administer new rights, we're just not going to build any projects in your state. So it's no coincidence that in 1903, Utah finally said, okay, well, if that's the case, we're going to go ahead and we're going to develop a comprehensive water law that allows us to figure out all these existing rights, remember all the grandfathered rights, figure out what they are, where they're at, how much they're flowing, and we're also going to have a system for appropriating new water rights. Unfortunately, in typical fashion, legislature failed to provide funding to actually do that job. What they kind of said is, hey, courts, you figure out the old existing rights by adjudicating them. And yeah, good luck with that. State engineer, you're going to be appropriating new rights. Well, the court doesn't work that way. The court has to have a case come before it, and then the court just kind of has these two parties, the defendant and the plaintiff, and they fight it out, and the court just kind of presides and says, all right, based on facts and law, this is the ruling. The judge doesn't go out and try to figure out water rights unless a case comes before him. So there was really no mechanism in order to accomplish what the state legislature had given a responsibility to the courts for adjudicating some of these old rights. In 1919, they finally figured this out, that it just wasn't working. And so they came up with this concept called a proposed determination. And what they said is, all right, state engineer, we know you're responsible for appropriating new water rights, but what we want you to do now is go into these areas and figure out all the existing rights that are already there and see how old they are, okay? And then what you're going to do is you're going to, using your expertise in water rights and your engineering expertise, you're going to make a recommendation to the court in a lawsuit, and the court's just going to rule on your recommendation. And so that's really the framework we continue to use today, in that the state engineer goes out, conducts a survey of the water uses and the water rights in the area, prepares a proposed determination, or otherwise known as an official recommendation, gives it to the court, and then the court issues a decree on it. So that was kind of, there's been some tweaks and changes that I'm going to explain here in a little bit, but that's kind of the genesis of why we have this process, all right? So prior to 1903, you didn't need a water right. You couldn't appropriate a water right? So that was, if you just started diverting water prior to 1903 on surface waters, you were grandfathered in, okay? Well, up until 1935, you could do the same thing with groundwater, meaning you could drill a well without a water right up until 1935. And then after 1935, they said, hey, well, surface water, groundwater, it's really all connected. We better start appropriating just to make sure we're not going to deplete these aquifers. So after 1935, you need a water right to have a well. But as you can imagine, 1935, although it seems like a long time ago, in Salt Lake Valley, it's pretty recent, and there are a lot of wells drilled without a water right. So they're part of these water rights that were grandfathered in. We sometimes refer to these as pre-statutory rights, whether they be surface water rights that were acquired or appropriated prior to 1903, or underground water rights prior to 1935. So that's another big reason why we have the general adjudication, is because we want to go out and find these old rights that aren't on our records. They're just kind of hidden. And we'll talk a little bit about that here. So prior to 1903, a comprehensive water law, water rights kind of fell into maybe 5 different categories. You had those that were decreed by ecclesiastical fiat, you know, you're going to get this much water at this time. Those that were filed for record at the county. Rights that were decreed by a court. Again, these are people that came and brought their controversy before the judge, and the judge said, based on my limited expertise in hydraulics and irrigation, this is how I think you should divide this river. Contracts and agreements, these are just kind of, let's say Salt Lake City did a lot of these. They would say, hey, we really like your clean mountain stream water. Tell you what, the Jordan River flows all year. We'll give you nasty Jordan River water for your irrigation if you let us take your clean mountain water to use for culinary purpose. So we have a lot of those exchange agreements that Salt Lake City has entered into in the valley. So we had some of those. And they had those claims that are never manifested in any record. These are the people who were grandfathered in, who were using water prior to either 1903 for surface rights or prior to 1935 for underground rights. And they never filed a claim. So they weren't on our records, and they still aren't on our records. So they just been using water because they had a right to use water. They weren't required to file anything. So that's kind of how water rights looked like up until that point in time, okay? As a result of that, there's a couple issues. First of all, there's no public record. There certainly wasn't a consolidated public record where you could go and say, I want to see all the water rights in Moab, or I want to see all the water rights in Davis County, okay? Since there was no record, over-appropriation was rampant. Often judges would decree more water than was actually even possible to run down the doggone river, and you just have people continue to stack appropriation on top of appropriation. And because the rights weren't defined, there's often a lot of controversy, and they had to be settled either by the court or by the church at the time. In his first one of his first biennial reports, the state engineer at the time, back in 1902, made this comment. He said, the definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record. So the idea was, hey, we're going to figure out all these grandfathered rights. We're going to figure out where they're at, how much they're diverting, and then we're going to start appropriating new rights. Well, as I mentioned before, the legislature failed to fund that effort, and so they decided, well, let's just start appropriating water rights. We'll figure out all these existing rights as we come along. So we have kind of these dual parallel tracks. You have the adjudication, and then you have appropriation. So these appropriation appropriates new rights. Adjudication looks at old and existing rights to bring them onto the record. And for those of you who weren't present when I first gave my introductory spiel, if you have any questions throughout the course of this, feel free to raise your hand. If it's something that's specific to your situation that may not benefit the group, I may just ask you to hold off, and we'll answer offline following the meeting. But for the benefit of all the group, if you have a question, I'm guessing someone else probably has the same question, so feel free to ask it. So what is a general stream adjudication? Sometimes we'll call it a water rights adjudication. Well, as its name implies, it's an action in state district court. It's a legal action. That's why you received that scary summons in that notice, right? It binds all the water users in the state, including the state engineer or the Division of Water Rights. That's the title of code that it's governed by, Title 73, Chapter 4. And the first general stream adjudications took place back in the 20s. You remember back a couple slides where I said in 1919 they finally had the machinery to figure out the proposed determination. The state engineer would go in and file that with the court. Well, he did that. So all of these colored blobs on the state of Utah is a different water rights adjudication. They typically follow hydrologic boundaries. So some of the first ones to be done was the Weber River drainage. That was done back in the 20s. The Sevier River and the Virgin River. And the Virgin River actually got reopened up back in the 80s, so we're going through that again. The rest of these have a little bit later date in the 50s. I'll explain why. When we talk about the Draper Subdivision, we're talking about a bite of the greater Utah Lake Jordan River general adjudication, so that big purple blob, okay? So this is really just a bite size, a piece of that bigger general adjudication. And actually, the Draper book has the is actually the last book in the Salt Lake Valley that we will initiate. Then we're moving on into Utah Valley. But if you look at this date, and it might be a little bit too hard to see, it was actually, it says 1944, but it's actually started in 1936. And so that's how long this general adjudication has been going. And we get a lot of questions, why are you guys doing this now to us? Does this have something to do with either some type of development, some type of other, either we're stooges for Obama or stooges for Trump? It doesn't, you know, it depends on your political ideology, on who we work for. But the truth is, we're just getting around to this part of the Utah Lake Jordan River just now, okay? We've expedited efforts in the last few years, so we're finally getting around. The west side of the valley, west of the Jordan River, was done back in the 70s and 80s, and then they spent their efforts up in the Bear River. I mean, it's a state program. I got a handful of people, and so we're just trying to figure out where the focus should be. State legislature and the governor's office has said you will focus on the Salt Lake Valley because that's where the most amount of urbanization has happened. That's where a lot of these old rights have disappeared, and we want to get them on the record. So let's talk a little bit more about that. Why do we do it? Well, we want to bring all claims onto the permanent record. I kind of talked about this a little bit already. We have those surface rights prior to 1903. We typically call those diligence claims, all right? And then we have those underground rights prior to 1935. We typically refer to those as underground water claims. But it's the same principle. They existed prior to the law that required them to be appropriated, all right? So prior to 1903, you didn't need a water right for surface. Prior to 1935, didn't need one for underground. I've said that a lot. I will continue to say that a lot because if people file a claim claiming that they're pre-statutory, they would have to demonstrate proof that they existed prior to those dates, all right? So that's why I'm kind of harping on that a little bit. And we'll talk about how to file a claim here in a few slides. We also have these things called federal reserved water rights. And it has nothing to do with the Federal Reserve that prints money or anything like that. This is actually something that's grown out of the Supreme Court. Back in the early 1900s at the Fort Belknap Indian Reservation, there was obviously a tribe of Indians there, and they wanted to become domesticated. You know, that's why they're put on the reservation, to assimilate into society, become domesticated, grow crops, and those types of things. Well, they said, well, we can't accomplish that unless we're able to divert water from the Milk River. And so they went to the state engineer, or the equivalent state engineer in Montana at the time, and the state engineer said, well, I'm sorry, you're out of luck because all the settlers around you have fully appropriated the waters of the Milk River. And of course, the Native Americans, the Indian reservation, said, well, that's not fair. We've been stuck here, and we've been told to do this, and we have no water to do that. So they took them to court. And the Supreme Court ruled that because the federal government had reserved the reservation, taking it out of the public domain, that there was an implied water right that went with that reservation. And you say, well, why does that matter to Utah? Well, we do have some Indian reservations, but that doctrine, that Winters doctrine, has also been applied to other types of federal reservations, such as Forest Service reservations, national park reservations, military reservations. All of these pieces of land come with this concept of a unknown, unquantified federal reserved water right. So the question becomes, well, how do you know how much water the Forest Service needs? And the problem is, you can never get them to tell you. They can never quantify it. It's just this unknown thing because they're the federal government, right? And what does the federal government have that no one else gets? Federal sovereign immunity, so you can't sue them, right? Well, fortunately, there was a senator by the name of McCarran out of Nevada, And he said, well, that's not fair. The western states are trying to figure out all these big projects and try to settle all the issues with regard to their water rights. And they can't do that if there's this looming unknown quantity of water that's associated with these federal reservations. And so he drafted a piece of legislation, a law that was passed in 1952. It's often referred to as the McCarran Amendment, which in essence waives the federal government's sovereign immunity with respect to water rights general adjudications. So the state can sue the federal government, and this federal government has to participate in this process. And even better, they have to do it in state district court, right? It's often this federal government will, if they do allow you to sue them, they'll say, well, you're going to do it in our court system. This is actually one of the only instances where you both they waive their immunity, and they have to appear in a district court, in a state district court. So it's kind of something pretty special. So water rights adjudications, that's one of the things we want to get at, because we have the whole Wasatch Front, and what's in the Wasatch Front? It's the Forest Service, right? So we are requiring them, they have to come to the table, they have to file claims, they have to say, hey, based on what we think we need, based on our reservation, this is what we think our water rights are. Another reason why we do it, we want to prevent everyone suing each other. We don't want all these lawsuits going forward, trying to keep track of what decree governs what particular water rights. We just want to get it all over in one fell swoop, one big lawsuit. And here's the thing that's going to be this is usually where the questions start kicking in. And usually once you get one question down, then other people feel a little bit more comfortable asking questions. But in the western United States, since water is a limited resource, part of the doctrine of prior appropriation, which is kind of common among, Colorado, Wyoming, all the western states, is this concept of use it or lose it. What they were afraid of is if they developed the system and some big water companies came in and say, I'm going to appropriate everything on the Bear River, and then people have to come to me to get their water. And so what they said, in essence, is, hey, if you fail to use your water that you've appropriated over a period of 7 years or more, that water right is subject to forfeiture. It goes away, all right? Another reason why that's important is people stop using that water is still being used by someone downstream, right? And so you have entire communities who develop based on the availability of that water not being used. And so they thought, well, it wouldn't be fair if someone suddenly came back and resurrected their water right and started taking that water, because people have become reliant on it. So that's the concept of use it or lose it. So one of the aspects of that is if you have a well and it hasn't been used for 7 years or more, it's probably subject to be disallowed by the court, all right? Happy to answer questions on that. It's kind of like the first, oh crap moment in the crowd we get. But that's just the way the legislature drafted the law. Yes, sir?
Question now, yeah, we have springs on our property directly. And when we first moved in about 35 years ago, someone is disputing our right to those springs. Never got to the court, but they
Threatened some litigation? Okay.
that water. My first question is, would that be possible? Can someone else take the water that comes from springs on which are on property that we own? I guess that's basic.
That's the basic question. I'm going to repeat it, summarize it for the benefit of the online audience and everyone else here. So this gentleman has some property. There's some springs on the property. They seem to be, you've been using the springs. At some point, an outside entity protested their use of the spring and said, hey, and threatened some litigation as to whether or not they had the right to use those springs.
That litigation is no longer an issue. That was a long time.
But, yeah, threatened. So the answer is yes, it is possible. So it depends. Do you actually have a water right for those springs? Simply owning the property upon which these springs develop does not automatically give a water right. So that's the number one. If you have a water right, then yeah, people can sue you for whatever they want to sue you. Whether they would prevail or not is a separate question, right? If you have a water right, then their chances of prevailing would be minimal to none. If you don't have a water right, then their chances of prevailing would probably be greatly bolstered. All right. So one of the things we can look at after this meeting is we can go and look at your property and see if there are any water rights of record that you're just not familiar with. So it may have been the case that whoever owned the property prior to you filed a water right on those springs. but they may not have. But if you don't have a water right, then in theory, that water, although it's emanating from the ground on your property, it's still part of the whole hydrologic system. And someone downstream has probably appropriated that water or has become reliant on that water. So I don't know the particulars of your case or your property, but we can look into it afterwards and see if there's a water right of a record associated with your parcel. Does that answer your question? Yes. Okay. All right. The last thing we want to do as part of this general adjudication is obtain a comprehensive decree on all the water rights. Having a decreed property right is kind of like the gold standard. And so if you make it through the make it through the other end of this process, the court will issue a decree on your water right and you're good to go. That doesn't mean you can stop using it for the rest of your life. Although we may never come around again, your neighbors could still, ultimately could still say, hey, you haven't used that water for 7 years, and they could take you to court, and the court could forfeit it through that action. So it's not an ollie oxen free type thing, but at least you have a bona fide certificated decreed right. Okay, so here's the process. It's kind of a three-phase process. The initial phase, we are at step number 4, all right? We're at the public meeting. The petition happened back in 1936. The Salt Lake City got tired of people dropping pumps in the Jordan River, sued like 1,000 people along the Jordan River, and the court said, hey, you can't do that. We're just going to do this because it affects more people than you have listed in your suit. We are going to transfer it to a general adjudication. Notice that was mailed out to you, or actually that was, the notice requirement is to publish it in the newspaper. We've done that. We've sent notice to you as well with that summons, and of course we're having the public meeting tonight. The next step, and I'm going to dive into these next steps a little bit more in detail in the subsequent slides, so don't get too concerned if I kind of gloss over them really quick. In about a week or so, we're going to send out a notice to file a claim. So if you have a water right that you intend on claiming, you will receive a notice. If you receive a notice for this meeting, you'll receive a notice along with a claim that you'll have 90 days to file. Now, upstairs, we have a big file room, and it has all these files of water rights of record. So when I say a water right of record, I'm talking about a water right that we know about. And that's either because it was appropriated through our office or someone has already came in and filed a claim on it, a diligence claim, and they brought it onto the record. Well, typically what happens is a lot of these water rights of record, if they're old, let's say it was for an old culinary well, Salt Lake City came in and now provides them culinary water, so they just abandon their well. Or some developer buys the farm and turns it into a Walmart, right? A lot of these water rights probably won't end up getting claimed. So if it's a water right of record and no one files a claim on it, it'll end on this thing called the list of unclaimed rights. And we will after that 90-day claim filing period, we'll gather that list together and we'll send you notice, hey, this list of unclaimed rights has been published, and then you'll be able to look on it and see, hey, is my water right of record, is it on here? Did I fail to file a claim? It's kind of a second chance to file a claim, just a heads up, hey, if you don't file a claim, it's going to go on this list. And what happens if you fail to file a claim, that list gets decreed and those rights become decreed abandoned, meaning no one's using them anymore, they don't go anywhere, they just become invalid, okay? The court rules that, hey, no one's claiming these, they're donezo. We'll have another public meeting to kind of describe what that means. And then if people do file an objection, let's say you have a water right of record, it ends up on this list, you say, oh, doggone, I just forgot to file a claim, you would file an objection, and we would resolve that objection. And usually when it comes to the list of unclaimed rights, we'd say, sure, we'll take your water right off the list of unclaimed rights. But we got to resolve all of those before the court can issue a decree saying that those have been abandoned. Okay, kind of the meat of this process comes once a claim has been filed. My team will go out, we'll take the claim, we'll do their best to contact the claimant if they provide us a phone number or an email to arrange a time to visit them in the field and take a look at their well, take a look at their beneficial use. So in essence, we're verifying the claim that it is in fact true and accurate. If it's claiming a pre-statutory use, meaning that if you have a well and it's not a water right of record, and you're saying, well, this well has been here since 1934, we're going to look for, you're going to have to provide evidence that substantiate it all the way back to 1934. Okay, and my team can give you some examples of what might constitute that type of evidence. We try to do our best to help people build that case if we can. Then once we've done an evaluation, we get all these claims and we say, all right, this is how we think these water rights should look. We consolidate them into the proposed determination and we file that with the court. We also send everyone who has filed a claim notice of that. So if you haven't filed a claim, you won't receive that notice, but if you do file a claim, you will receive it. People have 90 days to object, saying, I'm good, thanks. 90 days to object, saying, hey, my water right, you didn't get quite right. Either it's you placed it in the wrong location, or I really have more acres of irrigation. Again, you have 90 days to object. We have to resolve that before the court can issue the final decree on the proposed determination. So let's talk about filing your claim, all right? Because that's going to be your next step. As I mentioned, I forget the exact date. I have it here in the next couple of slides. Josh, you remember, is it in a week or two, we're going to send out notice? What's that? November 30th. So November 30th, we will be mailing out notice to file claims, okay? And we also publish it in the newspaper for a couple of weeks just to cover our bases. For those who are simply property owners, you'll receive the notice and you'll receive a blank claim form, all right? So water users claim, and it'll have a bunch of fields that you can fill in if you're savvy with that type of thing. If you're not savvy, we say come in and we'll help you fill it out. If you can kind of get us on target, we'll help you fill it out. Not a big deal, and you just file it right with us. Those who are owners of water rights of record, meaning we already have the existing water rights, we will send you a claim that's already filled out. All you've got to do is sign it and turn it back in to us. And you can either turn it to us or you can file it with the court. We're the easy button, but if you feel like filing it with the court, you can go that route too. But you have 90 days. Yes, ma'am.
Do they charge us for filing it?
No. I don't know if the court does. I don't think so. I think that's kind of a violation of due process. We don't. We just date stamp it and stuff like that. Matter of fact, you can mail it into us. You can email it to us. We'll take it however we can get it, all right? But you have 90 days to file that claim. If you don't want to come in and have us help you fill out, you can give us a call and we can answer your questions and we'll try to help you out over the phone as well. You have 90 days to file a claim. If you need more than 90 days, you can simply request. The easiest way is to use that email address I showed, adjudication_water_rights, to request an extension, but you have to do that before the 90 days expires, and then you get an automatic 30-day extension. So you have up to 120 days, okay? Once we receive your claim, Josh, who is the team leader, I failed to introduce him. You probably met him at the front door, but Josh is the team leader for this subdivision. Him or a member of his team will come out and evaluate your claim. If you claim a well, he's going to say, all right, show me your well. If you claim irrigation, he's going to say, all right, show me how you irrigate this using this well. If you claim that your well is buried beneath 3 feet of concrete and you can't access it, but it magically irrigates this lawn, it's going to be a tough sell, all right? So try not to reach for the stars. We understand these are valuable rights, and we want people to put them to beneficial use. So here's something I always say, if you have a well and it maybe just needs to be it hasn't been used for a long time, and you want to get it in use before our team shows up, I would encourage that, okay? We're not gonna be really hard-nosed investigators on whether, if in fact it looks like, has recently added some new PVC and hooked up. All we want to do is come out and see, hey, it's being used and it's good to go, all right? Now, if you have us come out and we look at it and it hasn't been used, and then you say, oh, wait, come back in 30 days. Well, I'm afraid at that point, we're not going to perjure ourselves, right? We're just going to make our evaluation or our recommendation to the court. So the key is file a claim and make sure when we show up that you can demonstrate that it's being beneficially used, okay? Again, we want people to use their water rights. We get nothing by taking them or not, we don't take them, but suggesting to the court or recommending to the court that they be forfeited. That really brings us zero joy. If we come out and everything's good to go, it makes our lives a lot easier. So we'll investigate the claim, we'll map the claim, we'll go back to our chairs, pontificate about your claim a little bit, and then we'll send you a state engineer's recommendation saying, hey, this is what we think your claim mounts up to. And then if you disagree with that, you can actually call us and talk to us, and we can say, oh, we failed to see this aspect or whatever. Or you can wait until the proposed determination comes out and object then, but we'll cover that in a second. Let's talk a little bit about the list of unclaimed rights. Remember all those files up in the file room of these rights that we have a record? Well, if there are no claims against those, they will be consolidated onto this list of unclaimed rights. Everyone who received a notice tonight will receive the notice that this has been published, and it will have a URL, a website link that you can go to find a PDF copy of it, okay? And we'll hold a public meeting. You have 90 days to say, nope, that's my right. I'm going to file an objection. If you file an objection, you have to file it with the court. You can't file it with us. Now we're kind of into the legal sphere where any proceeding has to go through the court. So you file the objection and a water user's claim at the same time with the court, and you would send us a copy as well. Again, if you get to that point and it's confusing, we'll kind of give you some pointers. Yes, sir?
I've got a very specific question.
Okay.
Time to talk
Oh, yeah.
one-on-one after?
Sure. I mean, you can give it once you ask the question, if it might help someone else in the crowd, and I'll.
We have several springs on our property. Some are productive, others are just sort of seepage that end up in a little stream. Horses are drinking out of the stream, domestic animals. Couple of things. I mean, do we file on the total volume of that that's going down the stream? If we file on it, does that suddenly make it known to the government, and we suddenly become under...
You've exposed yourself. Exactly. Yeah. Let me.
Won't tell you my address.
That's fine. It's up to you. At some point, if you file a claim, we're going to know your address, right? So let me repeat your question just for the sake of everyone. So he has these springs. Some are more productive than others. Some they just kind of go into the creek, and the horses, some stock watering occurs along that stream. How do we quantify that in our claim? Really, the quantification in the state of Utah, beneficial use is the basis, limit, and measure of the water right. So although we have these other facets such as CFS or acre feet, really what we want to know is what is it being used for? Because if you say I have 6 horses, we can quantify that into an amount of water because we know how much 6 horses need. If you have 2 acres of irrigation, we can quantify that because we know how much water needs to be applied for 2 acres. So that's the more important thing rather than worrying about the CFS or the acre foot component. It's the actual beneficial use. But I will say this, just because you have water on your property and horses are drinking from it doesn't mean you have a water right, all right? Matter of fact, your horses might be drinking illegally for all I know, and I'm sure they don't care. The horse is going to do what horse is going to do, right? So that answer your question?
Yeah, I think so.
Or just probably raised a whole bunch more, right? So again, if you object to the list of unclaimed rights, we're going to resolve that. Pretty much, it's pretty easy. If you just forgot to file a claim, in your objection, you simply list the reason why, file a claim, and we don't oppose those because, hey, file your claim and we'll look at it. Not a big deal. So although it's a big step to us, we just let the time expire. The court will rule in your favor. Big deal. And we remove the water right off the list of unclaimed rights. Then the judge will issue a decree for any remaining rights on that list of unclaimed rights. They'll issue the decree that those rights have been abandoned. And it'll also prevent any future claims to be made, and in the sense of any future claims of pre-statutory use, all right? So on the other side of that list of unclaimed rights, once that gets decreed, you can no longer be that guy who's claiming a pre-statutory use. That pretty much shuts that off. So that's one of the main purposes that the general adjudication was implemented, is to say, all right, you guys have had 100+ years to figure this stuff out. If you haven't filed your claim by now, we're moving on. Kind of shuts the door. Let's talk about the proposed determination. Again, as I mentioned, once they evaluate your claim, they'll send you what we're looking at, what we're thinking as far as our evaluation goes, and then we'll consolidate that into a proposed determination. It's just a book, has the water rights, has the various facets of what the water rights should be. That goes to the court. We issue a public meeting, or we have another public meeting to discuss it. If you don't like how the state engineer has evaluated your water right, in some cases, if your water right has been not been used for a period of 7 years or more, we may end up in that proposed determination recommending to the court that it be disallowed or forfeited. Okay, and so you might say, hey, no, that's wrong. You would then object. You'd file an objection with the court. You have 90 days to do that. Okay, and then we've got to resolve that objection. Now, there's a couple of ways we could do that. We can litigate it. We can stipulate. We can kind of negotiate a settlement. Typically, we try to settle these. If we are wrong, we have no dog in the fight to say otherwise. We are happy to correct ourselves and recommend to the court that they amend the proposed determination. But if you're trying to scheme the system or something like that and trying to be dishonest, then we'll probably end up litigating if we disagree on a fact or on a principle of law. And then once we get those objections finalized, the court will issue its decree and the book will be done, and we move on and hopefully never have to come back to the subdivision and bother you guys again in an evening. So let's talk about the Draper Subdivision specifically. In your notice, you received a map that kind of looks like this, but what this map shows, all those purple dots, those are all points of diversion, mix of wells and maybe surface diversions, all right? So you can see they're kind of clustered throughout the area. In this subdivision, we have 192. That's not a huge number. A lot of them are owned by Draper City, I believe, based on what Josh has mentioned to me. But there's probably a handful of privately owned water rights. Again, these are only the water rights that we have records of. There may still be these water rights that were maybe a well that was drilled prior to 1935 that we have no idea about, okay? The number of people, just a fun fact, number of people who we noticed or sent this summons to is around 12,000 people. You can see the stunning turnout tonight. A lot of interest in this, but it kind of ebbs and flows. So issues and anticipated timeline. So again, we have water rights of record, the big file room upstairs. They have the original appropriators' names on them. So even though you have now bought the property upon which that well resides and are using that water, that doesn't mean that our records automatically get updated. So often what will happen, and it may have happened to someone here tonight, we will send out a notice to the owner of record under a certain name, but it'll be coming to your address, okay? And that's so we encourage people, if they know they're in that situation, to update title with our office. That just means you need to update your records to reflect that you are the owner of that water right. And there's a whole separate process for that. It's a little bit more involved. It's called a report of conveyance. If you feel like you're in that boat, let's talk afterwards, and I'll kind of give you some pointers on what you need to do. We also have the issue with these no proofs required. So you saw that map with all those dots, and I can bring up a web interface that has that same information that everyone can access in the room. It's kind of a slick interface. But the thing is, a lot of these water rights are what we call no proofs required, because they were appropriated back in the 30s and 40s, the 40s. At the time, there weren't a lot of engineers or surveyors who could help them submit proof, because I'll back up a little bit. When you appropriate new water right, you have to file proof that you're using it within 5 years, okay? Well, at this time, all the engineers and surveyors were fighting Nazis in World War II, so the legislature said, hey, there's just not enough of those around. What we're going to do, if people have appropriated a small amount of water, we're not going to require them to file proof, which is great. The bad thing is that the location of where those wells exist and whatnot are really unknown. They kind of estimated their best guesses based on who was appropriating, but proof was never filed saying it is located here and it is surveyed so many feet from this section corner, okay? So when you look at these points and they appear to be out of whack or not really reflect, or they might be a well in the middle of a road, in the middle of your house, you gotta take them with a grain of salt. They're just based on some bad information, and it is what it is. So if you get close, then you can consider yourself lucky. But that's one of the things that we will do is we'll tie that location of that point of diversion better through this process. Okay, anticipated timeline, we already talked about November 30th, we'll send out the notice to file claims. That will start that 90-day claim filing period. February 28th is when that claim filing period will expire. We'll begin reviewing these claims that are filed. Around June 2019, we hope to publish the list of unclaimed rights, and we'll hold another public meeting. The 90-day objection period will begin. In September, that 90-day objection period will conclude. And then February 2020, sometime in that ballpark, is when we hope to have the proposed determination published. We are trying to get all the books in the Salt Lake Valley to be published at once. So even though this is one subdivision, we have lots of other subdivisions. We're going to try and publish them all together so that if there are legal issues that are common across these different subdivisions, they can be tried in the court at the same time. So there's a little bit of delay for all these books, and we're hopefully around February 2020, we can get them all published. And then if you use that February 2020 date, 90 days from then is May. That's when that objection period would conclude. And I saw, taking photos of this. This will be available on our website as well as we're recording it. You can watch this whole thing and be bored to tears all over again on YouTube. All right, so will I lose my water right? Those who are currently using their water right in conformance with the record of the state engineer have nothing to really worry about. As I said, just make sure it's put in beneficial use. As long as you file a claim, all right? So we got to file a claim. That's the big deal. It's not that hard, but sometimes people just are stubborn about it for some reason. Individuals without a water right of record are required to submit a claim during the process. Again, so if you don't have one of these water rights of record, you have an old well or a spring that you think predates 1903 or 1935, you need to file a claim, otherwise you risk being barred from doing that in the future. If the water right's fallen out of use for 7 years or more, it may be subject to forfeiture by the court. And how that works is we would go out and we'd say, well, we got aerial imagery. We have years of aerial imagery going back to the 60s and 50s. And if we can see it just hasn't been used in the recent past, we'll probably recommend that it be disallowed, or a portion of it. If you're only using 10 acres of your 20-acre water right, we'll only recommend that 10 acres be recognized by the court. Who do you contact? That's me at the top. Gary Brimley is my deputy. You can email him as well if you'd like. But Josh Zimmerman, he's going to be your guy. He's the team leader. He's going to be sending his troops out to review these water rights and actually interacting with you when you file your claim. We may have other team leaders and other teams, so if you do come in, Josh and his team doesn't have to specifically help you file a claim. We have other people that can do it, but they'll be the ones that are actually reviewing it. So, all right, any other questions? I'm going to look on my email and see if anyone's fired off a question. How about from the crowd? Yes, sir.
My water rights are through the irrigation company. Is there, other than just them representing my rights as a shareholder, is there anything specifically I need to do relative to my parcel?
That's a good question. So he uses water through shares in an irrigation company. The company owns the water rights. His question is, is there any other obligation I need to pursue? I would just say, the only thing that I would suggest doing is make sure the irrigation company is actively engaged, that they're notified, that they're responding to this, because they can lose their rights if they don't file. And make sure that you're using your shares, because if you're not using your shares, and let's say this irrigation company has a 100-acre water right, okay? So they have a water right that allows them to irrigate 100 acres, and we come out and we only find 90 acres, and you're the guy who's failing to irrigate his 10 acres, we're going to forfeit 10 acres off their water right. They're going to have 90 acres left, and then by Utah law, they can turn around and the shareholder who caused the forfeiture will have their shares either removed or reduced. So it's in your best interest and shareholders' best interest to use their entire shares worth of water and make sure that their board or their company is actively engaged. Good question. Any other questions? I'm not seeing anything pop up on my email. So while I got you here, I'm going to go online. I'm going to show you kind of some features of our website if you'd like to stick around. If you don't, No, it won't hurt my field bads, all right? We all got things to do. It's late night. But I'm going to show you how to navigate our website, how to look at some aerial imagery, how to find out if there is a water right of record on your property and those types of things, okay? So stand tight while I'm going to kind of adjust my, are we good, Paul, and keep on working on this? All right. Let's reduce the screen size just so that the whole... I just want you guys to be able to see the whole thing here. Yeah, that's good enough. Okay, so I'm just going to go to our home page, all right? waterrights.utah.gov. This is what our home page looks like. There's two ways to get to this map feature. I'm going to go the quick way, and then I'm going to show you the more helpful way that may provide other additional details. So the quick way is to go to this map search icon here, okay? So kind of right here, and you can see over here, okay? I'm going to select that link. And it will bring up this interface. What I'm going to do first, just because if I don't deselect points of diversion, it just gets too cluttered as I zoom in, all right? But let's go ahead and zoom in to Salt Lake Valley. And I don't have my mouse, so I'm just going to kind of do the best I can with a mouse pad here. All right, and we're kind of down here at the south end of the valley. So what I'm going to show you first is over here on the right-hand side of this menu, you see where my mouse is. There's a button that says Adjudication Books. I'm going to select that. And this shows all the different subdivisions that we are adjudicating. You can see your subdivision down here, 5726. So this big purple bite, okay? These are all the other ones. I just show that just so you know, hey, if you're curious whether a water right or a property is within the subdivision boundary, this is a lot easier to make that determination. So we can, if you're good at navigating aerial imagery and you know how you can, some people are better at it than others, so I'm going to say if you're just good at that and you can say, oh, I live by this big white building, whatever, I presume this is a school of some sort. So let me zoom in. Let's say you're this guy. You want to know, I want to know if I have a water right. So now I'd come back to points of diversion and I turn this on, okay? And you can see some red icons populate. Those are known points of diversion. So the red icons represent wells. So if you can kind of see how it looks like a well on it. If you zoom out, there's going to be a lot more here. The blue ones represent surface rights. So out of streams or those types of sources. So you could, if you happen to be this gentleman right here, I'm going to zoom in on this water right, 5790. Get rid of this because we don't really need it. So 57, 59, 43. So that's what water right numbers look like. They have the area number 57, which matches the book area number, and then 4 or even a 1 to 6 digit number after the hyphen. You can select on that icon and it'll bring up kind of a summary of information. But if you want more information, so for this summary, and this is just because I can decipher the code, the water rights code. Again, we have the water right number here at the top. I'll just use my mouse to highlight. Then we have this thing, the status. UGWC, that means it's an underground water claim. So this is a water right that was drilled, or well, it was drilled prior to 1935. And I know that because that's that status, and they filed a claim on it. But also because you can see here the priority date, this actually is 1922 June. So you kind of do it in reverse order where you go year, month, day. So in this case, the priority date's June of 1922. I wouldn't worry about the uses. That means it's irrigation and stock IS. I'm going to show you some more details. And the owner of it on our records is Utah Savings and Trust Company. This probably went into bankruptcy or the bank owns it. Is probably what it looks like to me. I'm not sure. But so if we click on that hyperlink at the top, it will take you to our actual database where you can find out more information. So that was just kind of a summary of those water right, of the facets of this of that water right. This provides all the details and will actually even show you the scanned documents or the documents that we have upstairs on the file. If I can get it to go faster.
What did you click?
Oh, sorry. Let me show you. So see how it has a URL link right there? No, you see
Oh, up there, yeah.
this blue number. I apologize. So I just clicked on the water right number,
Oh,
and that will bring up our database. Of course, I had happened to pick the only one that did not. That can't be right. It's got to be in there if it's on. I just think our database is not functioning here. Let's choose a different water right. That was a bad example. Hopefully there's a better one down here. Because I want to show you what our...
Blue icon.
What's that?
What is the blue icon?
Blue means that's a surface right.
Surface right.
So you can see point of diversion type is surface. The owner is Laura Clark. We'll select Laura. We'll see if that one works better for us. I'm not sure if we're just having a database. Okay, here we are. So this is working. It's just really slow. Usually it's not this slow. Okay, so this kind of provides in a tabular format all the details of this water right. You have the name and address of the owner of record, the flow rate allowed in that water, the source is drain water. And that usually, when you think of drain, you're thinking like a bathtub drain or something. Really what that is, in the olden days, they had irrigation on farms, and they'd have drains to collect the old irrigation water, and then it would discharge off their property, and people would file appropriations off of those drains. So that's really what that means. That's my guess, at least. You have the location, the point of diversion. You have what this is used for, what this is authorized used for down here. You have irrigation, and it's authorized to be used for 1.98 acres, and it's used for stock watering. And they have something called an ELU, 2 ELUs. ELU is an acronym that stands for Equivalent Livestock Unit. You guys see where I'm talking about here? So 1.98 acres and 2 ELUs. So that tells you that this water right is authorized to be used for irrigation for 1.98 acres and 2 horses, or 2 cows, right? One other facet or aspect of this, and you can kind of play around on this, but is the Scan Documents tab. If you do this, this will show you everything that we have in that file upstairs. So here's the original diligence claim. We select that, and it will bring up a scanned document of the diligence claim that they filed. So this is a claim asserting a pre-statutory use, meaning this water right had to have a priority date prior to 1903. Okay, see, and that's why you can see surface water prior to March 12th, 1903. Yeah, it looks like they, I don't see the priority date. Yeah, they just claim they have a generic one. Anyways, this is kind of what that diligence claim looks like, okay? And there's other documents. You can kind of look through that stuff if you'd like. All kinds of documents on these files, all right? So that's the map feature. And that's how you would navigate. If you're good at navigating on aerial imagery, and you can play around with some of these other components to this interface. But if you just say, I'm not good at doing maps, I just want to look up an address, you go to this search.
What are the pinpoints there?
Oh, that just means they are stacked on top of each other. And then this one, I'm guessing, is, what is this? Oh, it's a return, point of return, where the water returns to the source. Yeah, but these faded out ones just means there's multiple points of diversion stacked on top of each other. If you want to search by address, you can go to this search tab, put an address in. Anyone want to see if they have a water right in their property? All right, what's your address?
258 East Bridge Creek Way.
Bridge Creek?
Yeah, it's like one word. They ran out of room, I guess. Bridge over the creek.
Cool.
Way.
Way. This will take you to your house.
Oh, I'm having a party.
Yeah, look at that. Pool party. Unfortunately, they're not having a well party. I don't see any water rights in this area. But usually newer subdivisions typically didn't, because when the subdivision was in place, they connected to the city water.
I remember, I'm recently widowed, and I remember my husband telling me years ago, yeah, I got the water rights. I'm like, okay.
So you may have shares in Draper City Water Company, and that. So there's some, which again is a little bit different. I'm not sure what your husband may have been referring to. Yeah, look through the deeds and stuff like that when you acquired the property, and see if there's anything that specifies a water right or a water right number, anything to that effect. Yeah. So another thing to keep in mind is when people buy land, usually what happens is when they do a deed, they always say, and any water rights and appurtenances and mineral rights, and it'll just say quit claim everything, right? That doesn't mean that there are mineral rights or there are water rights. It's just saying, hey, if there are any, they're yours. So sometimes people get kind of confused on that. I'm not sure if that's the case or not, probably not the case, but some people say, hey, well, when I bought my property, it came with the water rights. Well, yeah, when I bought my property, it came with, they deeded any water rights to me as well, but there just happened to be none on there.
All I remember that it was several years after we had purchased the home.
Okay.
So
Yeah, well, look into it. If you figure something out, let us know. So, yes, ma'am.
So my shares are through WaterPro?
Yeah.
So do I still need to file a claim?
No, WaterPro is actively engaged in this. Yeah.
Okay, so I don't need to file a claim?
No.
My shares won't be posted on the site anyway?
No. WaterPro's water rights will, but they are responsible for filing a claim on behalf of their customers, and I've already talked with them. They're aware of this, so they're tracking. Yeah, I should have led with that, right? You could have gone home. I tried to.
So if you have subdivided land and you had to, as part of the subdivision process, had to purchase water rights through WaterPro, those water rights would be included in the water rights payment.
Yeah, so I'm gonna correct some terminology just because people get a little wrapped around the axles. Probably what you purchased from WaterPro were shares, or you didn't purchase water rights through WaterPro.
Right.
And so,
She can leave too.
yeah, so yeah, it's kind of a similar concept in that WaterPro is actively participating on the behalf of their shareholders or their customers. No, I mean, people in the past have been, really concerned, and so they'll file a claim on their shares just to make sure that everything is, out of an abundance of caution, and we don't blame them. What we do is we just take their claim and put it on the water right file for the respective company. Yeah, for WaterPro in this case, in this instance. Yeah. Okay, so that's how to get this interface. I want to show you one other feature on our website, okay? And then I'll happy to answer any more questions, or we can just come and I can answer individual questions. All right, so we're back to the home page. Another way to go is if you go to Adjudication. You see this hyperlink around here with the scales. You select it. And then you come to this, and you may have seen this. It is on the notice, but I'm not going to go with that. What I want to go to this Active Adjudications button at the top, okay? I select that, and here's a whole laundry list of all these subdivisions we're currently engaged trying to figure out, and you guys are going to be all the way down at the bottom, okay? So this is where you can track the status of any claim you file, or the status of a water right. Right now, nothing's happened. The only thing that's happened is someone's been served. So you see this white box. That's why all these are white. There might be one where there's a claim filed. We'll see. Is there, Josh? Yeah. So there you go. Draper Irrigation Company. So you can filter this list, or you can do a search to see if you're water right and see where it's in the status, whether, hey, we've received your claim, or we are reviewing it, or the field review is complete, or we've completed the state engineer's recommendation. And you can just go to this, and if you want to see, all right, if this is my water right, I'm John D. Jacob, I can select that map, and it will zoom you right into that water right, okay? Any questions on that interface at all? I'm not throwing a lot at you, but I just want to make sure we developed these tools for the public. I hate to see them not being used, but this is just kind of a better way to track the progress on your claim status. Is there any questions, any other questions? If they're not, yes, sir.
What if I wanted to drill a well? What do I do to?
Yeah, it's a great question. So he's like, hey, well, what if I want to drill a well? So there, you can still do that. There's a way to do it. So in the Salt Lake Valley, we are way over appropriated, meaning there's more paper water than there is wet water, okay? So years ago, they closed the valley to new appropriations, meaning you can't simply go to the state engineer and appropriate a new water right. But what you can do, or what you have to do these days, is you have to go and find someone else with a water right.
On your big list that's going to come out.
Or just go to this map, go hunting, and say, hey, this looks like and you want to get one that's kind of the same uses that you intend and as nearby as possible. And you also want to make sure it has been used in the last 7 years. And so you go and you can hunt for them. There's also websites. Heck, you can buy water rights on KSL.com. You can buy them off of, waterrightexchange.com or something like that.
Your Draper district area, do I need to be looking for something in the Draper area? Or?
Yeah, because there's prohibitions on how far you can move a water right. It's got to be hydrologically connected. So the regional office will be able to tell you, yeah, you would be able to move that water right into a well on your property. But there's just certain requirements so that they make sure that you're really, in fact, stopping use and just resuming the use in the same hydrologic strata so that it's not impacting or impairing existing water rights.
Are you guys mainly just doing the well water, or are you doing irrigation?
Doing it all. So irrigation, stock water, and power, municipal, you name it, it's part of this process.
Okay.
Other than calling our irrigation company, do we just have shares? How do we guarantee that they're doing it other than just filing a claim? Can we look at?
You can track their progress, yeah, and see if they filed a claim, certainly. And if their water rights happen to land on the list of unclaimed rights, then that's like the flag. You know, the flag should be going up, and you file an objection and say, hey, I'm using that water, even though I'm not the owner, and here's a claim, and then we'll take it off and we'll make sure it gets evaluated.
So say you decided to do a claim that you're going to stick under their name.
Mm-hmm.
Do I just find the form on the website?
Yeah, or you'll get a blank form here on November 30th if you want to use that to do that. Or if you know the water right number, you can get a claim form that already has that all filled out and just scratch out their names and put your own name in and file it. Sure. Yes, sir.
Do you know offhand if East Jordan Irrigation Company is actively involved in this process?
Yeah, I believe East Jordan Irrigation Company, I know we've dealt with. Mm-hmm. Yeah, for the most part, there aren't many irrigation companies that have escaped our notice, just because obviously there's a lot of people interested in preserving those. And Salt Lake City, you know, even though we're kind of well past the municipal boundaries, you know that Salt Lake, the fingers, the tentacles of Salt Lake City kind of, with regard to water stuff, kind of prevail throughout the valley. They have exchange contracts with a lot of these irrigation companies, so they're also vested in making sure that those company rights are protected. So, you know, there's a couple things that kind of work out in irrigation companies' favor just because Salt Lake City is very, very, very involved. I have a meeting with them once a month to go over their claims.
Another question actually, I think you said earlier, I just want to verify this, that irrigation runoff is also claimable. Someone can file a claim on the runoff.
So I talked about drains, right? So back in the day, you'd have people would flood irrigate, and then, you know, to prevent their land turning into a swamp, they'd make these drains at the end, and they'd collect the runoff, and then they'd issue out, and people would file appropriations on those drains. So yeah, that used to happen, but the basin's now closed to new appropriations, right? So you wouldn't be able to file a new appropriation on that. you may be able to file a change application, get a water right, and say, I want to now take the water that was diverted here, and I want to divert it off of this drain. That's a possibility. But that's not the same thing as storm drains, okay? Just want to make sure that we're clear there.
Yeah, there's irrigation runoff that occasionally accumulates in a small pond.
Yeah.
Can that be filed on that?
Again, it can't be newly appropriated because it's close to any appropriations. But it can, if you found a similar water right and filed a change to then take the water out of that pond, you may be able to accomplish that.
But no one's going to come along and file on the policy. They have no right to it.
Yeah, I mean, people file on all kinds of stuff, all kinds of crazy stuff. Whether we recognize it or not is a whole different matter. Yes, sir.
What if you own properties in two different jurisdictions?
Mm-hmm.
We're doing some developing on one of those properties. Is there anything that allows us to transfer water rights, say from Draper to Bluffdale, since it's pulled off of the same Utah lake irrigation system?
So his question is, you have development. Is there anything prohibiting moving water rights, say from Draper to Bluffdale across the Jordan River? You may be able to do that if you can demonstrate that the water. So a lot of these irrigation lines emanate from Jordan River or Utah Lake, right? So whether you take that water from Jordan River and now it's over here, or now you're doing it over here, you could potentially do that. The more challenging is moving groundwater from Draper to Bluffdale, right? Because it's not the same hydrologic basin. But if it's just surface water and it shares in a canal or something, there may be some opportunity. I can't speak super intelligently about the ability to do that because that's a regional office function. They'd be able to give you some details on that.
Who are the individual irrigation like he's doing? Who would you contact to do that?
So it depends on what you're trying to do. I presume you have shares.
Well, I own part of these shares in,
So you have shares in an irrigation company.
and I also own property in Bluffdale.
So you'd like to use the shares that you have in this irrigation company and use it in Bluffdale.
I'm developing the property in Draper on,
Yeah, so there's going to be a couple things. You're going to have to check with the bylaws of the irrigation company, see what they allow, and then because you're probably looking at, usually what people want to do is they want to take their shares and they want to put them in wells. Is that kind of what you're thinking?
no, I have two properties, both of them have surface water rights. I'm going to develop my property in Draper, and I have 14 acres down in Bluffdale, and on that 14 acres, I just want to extend the amount of
Okay, just irrigation though.
irrigation.
Okay. Yeah, it's going to be kind of, you're going to have to go a different couple of routes. Usually those shares stay in the system. You probably need to look at acquiring some shares elsewhere or doing a swap so that wherever your property in Bluffdale, whatever irrigation company services that, acquiring additional shares to cover that additional acreage. But I can't really, it's not my wheelhouse, unfortunately. A great place to start is the Utah Lake Jordan River Regional Office in this building, okay? Eric Jones is who you want to talk to. He's the assistant regional engineer. Yes, sir.
So, if I've got a share of water for an acre, and if I'm only using about a half an acre, can they come take that share, or will the canal company take that?
So that's a great question. So the question is, I have an acre of a share that's worth an acre, but I'm only irrigating half an acre. What's going to happen ultimately is what you're asking, right? So what's going to happen is we're going to come out and we're going to evaluate the irrigation company's water rights. And all we care about is, hey, irrigation company, show us who has shares, and then we're going to go and map that irrigation. So if someone else is irrigating 1.5 acres of irrigation and they only have a share for 1, and then it's, to us, it's no difference because we're just looking at the rights. We don't care how the shares are split up among the shareholders. But if there's a deficit, meaning that all the shareholders can show less irrigation than the shares would permit, then we're going to reduce the water right of the company, And then it's up to the company how they want to treat their shareholders. But usually, so as I said, the Utah state law allows the company to go after the shareholders who fail to use their entire share. So there's a couple different scenarios that could play out. And then the third scenario, which is kind of the wild card, is, does Salt Lake City own this irrigation company, or is this irrigation company owned by a public water supplier? Because public water suppliers have better lobbyists than irrigation companies, and they got written into the law back in 2008 that they are immune from forfeiture. So if the company is owned by a public water supplier, so let's say the company is owned by Salt Lake City or Draper City or WaterPro, or these types of entities, they're statutorily immune from us reducing their water rights based on non-use. So that's kind of the wild card. I don't expect you really to understand the contours of that, but there are some protections out there for public water suppliers, including municipalities. So, I'm not sure, I can't recall if Draper City obviously fits in that category. I almost want to say WaterPro does as well, because I thought we had this discussion, but don't take that to the bank. I need to, was that the case?
Draper City and WaterPro are
The same, right? Yeah, that's right. So it's probably not an issue, really. And that makes our life easy, because then we don't have to worry about it. And we just don't have to worry about all the hate mail and discontent. So, yes, sir.
Do you guys also control thermal water underneath the ground?
So we do, yes. So remember when I said that the basin is closed to new appropriations? What I really meant is closed to consumptive appropriations. So people can still drill thermal wells that are non-consumptive, meaning they're just recycling the wells. But yeah, that's still through the Division of Water Rights. We don't adjudicate those because they're kind of a different class of well.
Who would so I own property also next to the prison that was shut down. 60% of the prison is heated on thermal activity.
Uh-huh.
I have water that actually pumps across my property and heats the old Bluffdale roses. Just who do I contact to find out whether or not I can access that and pump it back into the ground?
Well, I mean, it's got to be a closed loop, right? So, I'm not really sure what the scenario. I'm not confident I understand the scenario you're describing. But if you're interested in drilling a thermal well, you would contact our office. So Jim Goddard is the gentleman who's in charge of the well drilling program. He would be able to talk a lot more intelligently about that process than I am.
There's already thermal wells there though, right?
Well, not on my property. Bluffdale Roses has 3 of them, 2 of them shut down. And they come from another well across my property, and they return it to a thermal pond. So it loops all the way around.
Yeah, see, if it goes to a pond, there's going to be some consumptive use. So I'm not sure what's going on there, because there's going to be evaporation, right? So when I talk about non-consumptive, I mean a completely closed loop. Pump it up, it loses heat, and you inject it back down. It's a closed loop system. I'm not sure what's being described there, and I'm not going to talk to it. But if it consumes water by evaporation, you will have 0 chance of getting a new appropriation. But usually the thermal wells I'm familiar with are closed loop, and so that's what I was gearing my comments towards, I suppose. But talk to Jim; he'll be able to answer your questions. Paul.
Can I ask you to check for online questions?
Oh yes, absolutely. I do have one. So this is a question from a gentleman. Has Draper Irrigation, parentheses, WaterPro, secured their water rights? Draper Irrigation, so I guess that depends on what you mean secured their water rights. They have not filed claims yet. I anticipate they will file claims. I don't expect any issues with Draper Irrigation / WaterPro participation in this process. Like I said, I met with them a few months ago just to give them a heads up that this was coming down the pike. I fully expect them to be actively engaged and they have attorneys all over this. So I think that was the only question I got. Yeah. Any other questions? If not, then we'll conclude this public meeting, and we will stand by for if you want to come up and look at the computer and help you out individually if you like. And then we also have Josh and Nick and Sam back here and Jen that can help you out as well. So thank you. You look like you have a question.